Legalities Part 1. The Nurse Practice Act, we've touched on this over and over again since the beginning of your nursing student career. But it's that important because it establishes or defines the nursing practice and establishes standards for nurses in each individual state. Not knowing what the Nurse Practice Act contains is never an excuse and is never a defense that is acceptable. LPNs have to understand their legal role as outlined in the Nurse Practice Act. Not all healthcare professionals correctly understand the LPN's role. The Nurse Practice Act is the final authority on nursing practice. LPNs have to be clear on their responsibilities to avoid situations outside their scope of practice. So, what do you think would be a consequence if an LPN performs an act outside of the scope of practice allowed? Yes, you could potentially lose your license. The Nurse Practice Act will commonly include a variety of things, including the definition of nursing, of the different types of nursing, the titles, the scope of practice, what constitutes unprofessional conduct, and what does the State Board of Nursing actually do? Well, the primary responsibility of the State Board of Nursing is to ensure the safety of the public and to ensure the professional conduct of the nurse. They are responsible for the licensing and discipline of nurses, in addition to other duties. Some states will now post professional licensure related information, such as disciplinary action, on the internet, so the public has access to it. Committees or councils that decide whether specific activities are within the scope of nursing practice in their state are within the State Board of Nursing. Because an activity is legal in one state, though, it does not make it legal in another state. So there is a variety of areas that nurses can be disciplined by the State Board of Nursing. And again, you've got to get in that Nurse Practice Act so you understand exactly how or what constitutes disciplinary action. The nursing licensure will protect the LPN's title. The examination is a national examination, the NCLEX. It is the same test that is taken in California is the same one that's taken in New York, is taken in Kansas, etc. So, a successful completion of that examination, then the graduate will receive a nursing license. It is possible to work in other states with special requirements. There are interstate endorsements. So you can work in another state without taking the LPN NCLEX exam again, but you have to meet that state's criteria for licensure. For example, the state of Kansas, you have to have practiced within a certain number of years, and you have to have current licensure, etc. So there are certain criteria that each state will set forth. There is such a thing as a multi-state licensure. Kansas is not one of those states, but this allows a nurse to have a license in his or her personal state of residency and practice in another state without having to obtain a specific license in that state. There's only a limited number of states that subscribe to this. Unlicensed assistive personnel are the CNAs, and we know that CNAs are trained to perform a variety of nursing tasks. LPN can supervise the CNAs, but if you require the CNA to do a task that is not within their scope of practice, it's your license that will be at risk. The RN ultimately will have the final say in the supervision, but again, LPNs can be supervisors. The nursing standard of care is going to be the guideline for the minimal level of care that's expected in certain areas. You are held to that standard of care, and if a case ever comes to court or comes up for review, that is what they look at. Was the care that was provided equivalent to the standard of care that would be provided in the same type of institution that has about the same number of staff, the same number of beds, the same number of services, etc.? Was the standard of care equivalent? Did it meet the standards? It's very important for you to be familiar with the different types of laws that are out there. A common law is called judge-made because it originates in the courts, and this is like informed consent or the right to refuse treatment. However, statutory law is developed within Congress, and an example of that is the Nurse Practice Act. So one way to think of common law is that it's the judge's interpretation of statutory law. The judge's rulings will help define the laws that are on the books, which are statutory law. Statutory law is often rather vague and does require some interpretation as to its intended meaning. So what separates criminal from a civil action? Criminal action will involve people and society as a whole and relationships between the individuals and the government. Civil action will protect individual rights and result in payment of money to the injured person. Civil and criminal actions are two different systems. Civil actions can be filed even after a criminal action is unsuccessful on the same issue. With a misdemeanor, this is a less serious charge. The penalty is usually a fine and/or no more than 1 year prison sentence. Whereas a felony is definitely more serious, and the penalty will result in more than a year's prison sentence, up to and including death. But guilt must be proved beyond a reasonable doubt. Unfortunately, some innocent people have gotten through or gotten into the prison system, so CYA. Torts are the next level of legalities that we're going to talk about. There's intentional and unintentional torts. Intentional is exactly what it says. It's intended to cause harm, whereas unintentional is not meant to cause harm, but it does. Intentional will include assault and battery. Assault is an unjustified attempt or a threat to touch someone. It doesn't involve the actual action of touching. Battery means to cause physical harm to someone, so touch comes in under battery. Patients do retain the right to refuse any treatment verbally, and they can leave the institution when they choose, unless they are there for court-ordered treatment. Treating a client without consent is considered to be battery, even if that treatment is medically beneficial. False imprisonment would be keeping someone detained against his or her will. This also includes the use of restraints. Defamation is damage to someone's reputation through false communication or communication without their permission. Now, libel is defamation, but it's done through written communication or pictures. Slander is also defamation, but it's done through verbalization of untrue or private gossip information to a third party. The patient has the right to expect you to speak the truth. Additional unnecessary conversation with coworkers and those outside the agency can result in a charge of defamation. The same is true for taking unwanted photographs or showing a client's injury, cancerous growth, gunshot wound, etc. to others. This includes students without the client's permission. Physical and emotional abuse. You've got a legal responsibility to report your suspicions or observations of abuse by following your facility's abuse policy. It's important to be empathetic as opposed to sympathetic so that your observations or reporting will be as objective as possible. Make certain that you offer concrete, specific observations. Quote statements made and avoid offering a personal interpretation. In other words, the patient seems belligerent versus patient is striking out at staff and is very loud using coarse language. Emotional abuse is often difficult to identify. Physical abuse is usually easier to identify, although the victim may find creative ways to hide the injuries for a period of time. So let's look at unintentional torts. An action that is not meant to cause harm to the patient, but does, again, is what an unintentional tort is. They can be just as devastating to the party who is charged, even though the intent was not present. So usually the nurse did not maintain the nursing standard of care and did not do what a prudent nurse with comparable education and skills would do in a similar situation. Negligence is conduct which falls below the standards established by the law for the protection of others against the unreasonable risk of harm. It's your conduct, not your intent, which is the issue. Malpractice is also an unintentional tort, as is negligence by a professional. Common source of malpractice would be medication and treatment errors, a lack of observation and timely reporting on the client, defective technologies or equipment, infections caused or worsened by poor nursing care, poor communication of important information, including a change of condition, a failure to intervene to protect the client from poor medical care. All the charges of professional negligence or malpractice could be avoided by using good nursing practice. So should nurses attain malpractice insurance? Well, this is an individual thing, and each nurse has to consider whether it is going to be appropriate for them or not. Incidents of suing for malpractice will continue, but chances of being sued as an LPN are statistically small. Make sure that you look at the policy that the agency you're employed at holds. Nurses do assume liability for their own acts. Although the employing agency may assume responsibility for the nurse during a lawsuit, the agency can then turn around and sue the nurse. You can also be held responsible for the neighborhood advice that you give. For example, telling a neighbor how to care for her sick child. If your advice is inappropriate or the child suffers harm because of the advice that you give, that neighbor can sue you. There's 4 elements that are required to prove negligence: duty, breach of duty, damages, and proximate cause. In order to establish duty, a relationship in which duty was owed has to be established. In other words, was this client assigned to you? Duty includes a professional relationship between the nurse and a client. If there's no damages from breach of duty, then there's no case. So if you adhered to the nursing standard of care, then chances are there will be no case. To establish proximate cause, the plaintiff has to demonstrate a link between the act and the damage that was suffered. So there's steps for bringing about legal action by a client. The nurse's attorney will prepare the nurse prior to giving a deposition or testimony. The attorney cannot tell the nurse what to say, but can describe what questions to expect. It is acceptable for the nurse to admit that he or she doesn't remember or doesn't understand the question. It's also inadvisable to give more information than is asked for in response to a question. In other words, answer only the question in the briefest words possible. Always be truthful. It is recommended to pause prior to answering a question from opposing counsel. This pause will help you gather your thoughts and prevent you from saying something that you didn't intend to say. If your attorney recommends that you do not answer a question, then don't answer the question. Consider consulting an expert regarding the need for personal liability insurance. Of course, insurance agents are going to always recommend that you have insurance, but you need someone that you trust who knows what they're talking about when determining whether you need liability insurance or not. Ask to examine your facility's liability insurance regarding coverage for nurses. Hospital insurance policies often cover employees only if the employee follows hospital policy during an incident. So what are implications for nurses of the borrowed servant doctrine? And what are implications for the nurses of the captain of the ship doctrine? Nurses have to be responsible, and nurses have to be accountable for their actions. Being accountable for your actions means that you admit when you make a mistake. You admit when you forget something. It's not always easy to do because you don't necessarily want to appear less than perfect in someone else's eyes, but at the same time, when you admit to your mistake, it often will improve the relationship, whether it's an employer-employee relationship or a friend-to-friend relationship, a working relationship. Measures of accountability can be found in these areas: the Nurse Practice Act, the NAPNES Standards of Practice, the NFLPN Nursing Standards, and the NFLPN Code for Practical Vocational Nursing. So, are student nurses liable? Well, yes, they are. They are held accountable for the care that they give. You as a nursing student, have been trained to perform certain tasks. As long as you do not go outside of your scope of practice, or if you have a question about the procedure that you're to perform, or you perform it incorrectly, these are considerations that are taken in, or these are things that are taken into consideration. Your nursing instructor is responsible for making assignments that are within your knowledge base and within your ability to provide safe care. Your nursing instructor can review procedures with you. Your nursing instructor can counsel you or guide you as you are performing it. But if you perform it incorrectly, you will be the one who is held liable. If it is within your knowledge base and proven ability through checkoffs to perform. It is also expected for your instructor to provide reasonable supervision for the care. Now, that care does not, or supervision does not mean that the instructor has to be the one providing the supervision 24/7. It can be assumed by a nurse that you are working with, as long as that nurse is at least an LPN, if not a higher degree. So if you function beyond the scope of practice, you can be held liable. It is up to you to speak up, to know what your scope of practice is. Really study that Nurse Practice Act, because a lot of RNs don't know exactly what that scope is for the LPN. When you're seeking out employment, make sure that you check out their philosophy and mission statement. Ask what will be expected of you, how much orientation you will receive, etc., and who's going to be doing that orientation. The orientation should be provided by someone who is at least an LPN, if not an RN. If you discover during your inquiry that your work is going to cover more than what you've learned, or tasks that are beyond your scope of practice, then you've got to speak up. Getting a job just to get a job may result in your being fired or losing your license.